Let's go on to record in the case of the People, State of California versus Kellen Winslow II. The record reflect the presence of all counsel. You can have a seat. Mr. Winslow is also present. We left off with a couple of motions that were kind of hanging there. We did do a McCoy hearing that was in chambers. That transcript has been sealed pending further order of the court. There was just one additional written in limine motion that needed to be addressed, which is the additional defense motion in limine, and that has to do with some prior consensual sexual conduct involving Jane Doe number 2. The people are opposed to any reference to that. Is that correct?
That's correct, Your Honor.
All right. Mr. Carlos, do you want to be heard?
The issue before the court, and this court recalls during the last trial also, we attempted to establish that there was, through the victim's own admission, she had a sexual encounter with an individual whose DNA was actually on her person, which was a consensual act. However, the injuries in this particular case were redness in the vaginal area and redness in the anal area, and they're non-conclusive. In other words, there's just redness. They can't tell what they mean, where they came from. The defense sought to introduce this testimony because the case law specifically has made allowances for this type of testimony when there's a possibility it's an alternative explanation for the injury. If you consider the redness in the vaginal area and the redness in the anal area as injuries, then this would be an alternative explanation for that type of finding by the sane nurse.
All right. Now, wouldn't that be more relevant towards the forcible rape charge, though? Because that's not on the table anymore.
It would, except that there is also additional contact. We didn't get a chance because we were precluded from even asking about this. We didn't get the chance to ask what type of activity she was involved with this individual who left the DNA. In other words, it could be very well. I mean, she did tell the nurse that it was a vaginal encounter with her previous boyfriend, but she was never able to be cross-examined on it. So we don't know whether or not there was any type of activity, what type of activity she engaged in, which might lead to that redness.
All right. So just to be clear, what are you seeking to introduce?
Just
her statement.
It's the existence. There is DNA of an individual, Bobby Guzman, who is her boyfriend. Mr. Winslow's DNA is not. In other words, she claims that she was vaginally raped and potentially sodomized by Mr. Winslow, and there's no DNA. The only DNA that Jane Doe 2 has on her person is that of Bobby Guzman, who apparently somewhere in the area between 1 to 4 days she had a sexual encounter with.
All right, Mr. Owens.
Thank you, Your Honor. Just to clarify factually so that the court is aware of the specific statements that were made to the SART nurse by Jane Doe 2. She did admit into the standardized questioning in terms of the pre-sexual assault history that approximately 3 days prior to the sexual assault examination, she engaged in consensual sex with a consensual partner that they've identified. She specifically stated that that was penile vaginal intercourse and that other consensual partner's DNA was collected from her vaginal area, as well as there was a very, very low level of inclusion along her fingernail scrapings of that same consensual partner. The last trial, the defense attempted to get into that area of cross-examination with Jane Doe 2, and the court, I think, rightly precluded them from doing so because that's exactly what Evidence Code Sections 782 and 1103 are designed to prevent. The possible spillover impacting the credibility of a sexual assault victim just by virtue of the fact that they've had consensual sex with a partner shortly in time prior to the reported sexual assault. In that situation, ultimately, the defense and the people, based upon some of the case authority cited by the defense, stipulated that Jane Doe 2 had, in fact, reported to the sexual assault nurse, Ann Williams, that she engaged in that consensual sex because I think Mr. Carlos wanted to be able to argue that Jane Doe 2's redness, the erythema that was located in her vaginal area, could have an alternative explanation. The people were willing to stipulate to that fact at that time. In this trial, however, that issue is no longer before the jury to determine whether or not a forcible vaginal rape of Jane Doe 2 occurred. Jane Doe 2 never reported and has never said that she engaged in any consensual penile anal intercourse with her consensual partner. Therefore, Mr. Carlos's offer of proof as to its relevance, I think, is lacking and should not overcome the presumption that any consensual sexual activity should be barred. So the people are asking that the court preclude any questioning or any examination as it relates to Jane Doe 2 or Nurse Ann Williams that would implicate these rape shield statutes that we have on the books.
All right, anything further, Mr. Carlos?
No, it's in the motion.
Can I also add, it's not only just for the DNA, the sperm of Bobby Guzman that's found in her vagina, but it's also under her fingernails. So that goes to the choking allegations that she makes, which relates to the sodomy count, where she is pulling the fingers off of her neck, but there's no DNA of Kellen Winslow Jr. under her fingernails. Instead, what's under her fingernails is the DNA of Bobby Guzman. So if Your Honor, we're asking that the DNA come in for both the sperm of Bobby Guzman and his DNA, which is under her fingernails. The fingernails goes to the choking, which is in relation to the sodomy count, and the sperm is related to the penetration in the anal vaginal area.
But how does her prior consensual sexual intercourse with her boyfriend, then, how does that become relevant because the DNA under the fingernails?
No, that's the choking. So we don't have to say sex, but we can just say his DNA, depending on what Your Honor rules, is under the fingernails. It wouldn't be sperm that's under her fingernails, it would be his DNA, which goes to the choking and the sodomy count.
Okay.
So I don't want you to preclude all DNA if you're intending to preclude the sperm. So there's two different types that we're talking about. The sperm that's in her vagina, that she had consensual sex with him, but she doesn't describe the consensual sex, and it could have been in the anal area as well, because we were not allowed to cross-examine on that previously.
All right. Well, the court will stand by its previous ruling in the earlier trial. The evidence of the consensual sexual intercourse that she had with her boyfriend will be excluded pursuant to Evidence Code Section 782 and 1103. Especially at this point in time, given the fact that the forcible rape charge involving Jane Doe number 2 has been resolved, any redness in her vaginal area that may have been caused by consensual sex with her boyfriend is not relevant, because the only charge left with respect to Jane 2 is the act of forcible sodomy. So any redness in the vaginal area that may have been caused by the consensual sex with her boyfriend is not relevant, and what marginal relevance it might have is certainly does not survive a 352 analysis. There's almost no probative value whatsoever to that evidence, so it will be excluded with respect to her testimony and any questioning of the nurse. It's 10 o'clock. We're about ready to bring the jury in. There's one last motion, and that had to do with whether or not, well, how we address the victims or the complaining witnesses. I'm fine with letting Mr. Owens refer to them as victims. I'm fine with letting the defense refer to them as complaining witnesses or alleged victims, however you want to do it. But Ms. Von Helms, you said you might have some case law that would support your position. It would not allow the prosecution to refer to them as victims?
Yes, Your Honor. It's essentially this case law. The statements that the prosecution makes are assumed to make an impression upon the minds of the jurors because the weight of his office carries such weight with the jury that his or her statements of fact predicated on, in this case, his knowledge rather than on the evidence can constitute reversible error.
It sounds like you're quoting a case. Can you give me the case
Yes.
site so I can take a look at it?
This is People versus Purvis, Purvis. It's a 60 cal second, 323 at 341.
Just a moment. 60 cal second what?
323 at 341. So it's basically saying that what the prosecutor says, it's kind of akin to a vouching argument. They carry such weight that when he calls them victims, when they are not yet decided as whether they are victims, in fact, by the jury, that's not based on evidence, but that's based on his opinion of their credibility. And so by him referring to them as victims, that can taint the jury and cause them to believe the same thing. In addition, Your Honor, there's People versus Daggett, which is a 1990 case, 225 Calap 3rd, 751 at 759. This says a lawyer cannot use subterfuge to place before a jury matters which it cannot properly consider. When a lawyer asserts that something not in the record is true, he is in effect testifying. This is improper. That's a Ninth Circuit opinion from the federal courts, which indicates when the prosecutor speaks and says something is true, i.e. this person is a victim, it places in front of the jury his, i.e. the prosecutor's testimony and not the testimony of the witnesses.
All right, looks like in Daggett, the prosecutor did use tactics that violated the rules of professional conduct. That's a far stretch from allowing the prosecution to refer to the witnesses as victims. In Daggett, the court said it is a prosecutor's duty to see that those accused of crimes are afforded a fair trial. That's a quote from Daggett, but it does not stand for the proposition that the prosecutor cannot refer to the victims in this case as victims. So I'm going to allow the prosecution to refer to them as victims. You can refer to them as alleged victims or complaining witnesses. All right, so that finishes all the pretrial motions. Why don't we do this? Why don't we bring in the jury? We'll pre-instruct them right now. We'll move right into opening statements. So let's go ahead and bring the jurors in. And can I see counsel at sidebar off the record?